Mr. Chairman.
Articles of Confederation now resolve this convention. The national government ought to be established.
Consent to this Constitution.
Welcome back for Lesson 10. Here we're going to discuss Article 4 through 7, the states and the people. We'll be discussing the relationship between the states, the amending powers, supremacy, and ratification. Now, prior to the adoption of the Constitution in 1789, many of the states were treating each other as foreign powers. Article 4 was designed to solve some of the most abrasive problems that had arisen among the 13 original colonies. The founders also wanted to cover additional problems that might arise as new states came into the Union. So, for example, one of the first things that the Constitution does is determine how the states are going to handle each other's different acts, official acts. And so this is where we get to a clause that's called the full faith and credit clause. So faith and credit is your first blanks there for letter A. And basically what this means is that each state will recognize the official acts of each other. Now, who gets to determine what is proof? Proof is your blank for letter B. As to what determines an official act, Congress can determine that. So, for example, marriages or even a driver's license, those all should be recognized from one state to the next. Now, you might have a question, well, what about things like the current issue of same-sex marriage? Does one state have to honor it for another state? And the Supreme Court has made it clear, and Congress has made it clear, that if one state already has something illegal, the act of another state can't automatically override the laws of the original state. And so this full faith and credit does not give priority to one state over the other than the state itself when you're in that state. So for example, if you came to Arizona and you had a Florida driver's license, we absolutely will recognize that Florida driver's license. You can come and go through Arizona, you take a vacation, we welcome you to come and visit the Grand Canyon, fantastic place. But the moment you decide to move to Arizona, we have a law that says that if you're a citizen, you have to have an Arizona driver's license within 30 days. So once that 30 days hit, we will no longer recognize that Florida driver's license because you are now a citizen of the state of Arizona. So just because one state has one law doesn't mean it automatically overrides the law in another state. And so there's a little bit of a gray area there with that full faith and credit. But nevertheless, we will recognize the official acts of each other. And then Article 4, Section 2, the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. So this basically is referring to natural rights, some of the natural rights that we discussed in some of the earlier lessons. And so we are able to freely travel in those states. We can freely set up businesses in those states. Of course, there may be some regulation on how to do that. But we're able to basically be just as free in other states as we are in our state that we reside in. Letter B, it does not include acquired rights of citizens. Okay? Again, these are things like the driver's license once you move there. Again, number 1, this would include such things as hunting, fishing, right? You still would need a hunting license, and it would have to be an Arizona hunting license or whichever state you're going to. In these cases, extra fees is your next blank, can be charged to citizens of other states. So a good example of this is higher education, right? In the state of Arizona, we have a law right in our Constitution. It says that the state has to provide higher education for as near free as possible. But the moment somebody from outside of Arizona comes in, they are no longer under that state constitution, so therefore we can charge whatever we want to for the higher education. So that's where you get the different tuition prices for residents and non-residents, right? Then Article 4, Section 3, it relates to the creation of new states. So new states can be created by dividing existing states, or combining existing states, or creating new states out of federal territories. So dividing, combining, and creating, your blanks there. However, this can only be done by the consent of Congress and the legislatures of any state involved. So Congress can't just come in and divide a state. Those state legislatures have to be involved. Same thing with combining states. Okay? Obviously, if it's federal territory, there are no states involved, and so therefore only Congress has to determine when that happens. Now, number 3, the Northwest Ordinance adopted by Congress in 1787 provided that all new states would enter the Union on equal is your blank, equal footing with the original states in respect to whatever. That's everything. And the reason why this was done was because, as the new states were going to be coming to the Union, sometimes the original states want to have a little bit more privilege than those new states. And they said, no, we don't want that to happen. Now, this is kind of where this the land thing becomes an issue as well. Because originally, all these other states came into the Union, and they did not have this requirement of having to leave, 85% in the case of Nevada to the federal government. And so the western states came into the Union on an unequal footing, in my opinion. Letter B, only Congress shall have the power to regulate or dispose of territory or property belonging to the United States. So when Thomas Jefferson worked out the Louisiana Purchase, only Congress had the authority to sell that land and to distribute it and turn it into states and things. In fact, that's the one way that the federal government has been able to, on 2 occasions, get our national debt down to 0. Only 2 presidents pushed that through Congress, Jefferson and Jackson, and both of them did it the same way, and that was by selling federal lands. And you see what happens is not only do you get the initial money from the sale, but when you turn the land back over to the people and let the people cultivate it, let the people add their labor to the land, what do we get when we take nature and add labor to it? Wealth. That's right, we get wealth. And so then it increases the tax base, and so the government ends up in the long run getting more money out of it as well. Okay? So turn the land back over to the people if you want to solve our financial problems. And that would be a huge solution for these problems in the western states. Arizona, 75% of Arizona is owned by the federal government. And out of that 25% that's left, half of that is owned by the state. So only about 12 to 13% of Arizona is owned by the people. Right? That's a pretty low percentage. Turn the land back over to the people. We usually take care of it. Every once in a while we abuse it. It's true. But usually we correct ourselves, and we normally take care of it. We cultivate it, right? Then we get into Section 4, which isn't listed specifically in your book, but in Section 4, letter C is what's included there. The United States shall guarantee a Republican or representative form of government in each of the states. So this is one area where the federal government does have the authority to tell the states what their government has to be like and the kind of laws and things that they have to have. It has to be a Republican form of government. Now, in my opinion, states like my own state that has proposition systems and referendums and recall and all those things, that is a violation of this provision, because all those things are democratic forms of government, not Republican forms of government. And it's caused a tremendous amount of problem when you have these propositions and the people get in there and they get all emotional and they start passing laws. We actually passed a law in Arizona. It was a proposition that says that any proposition that we pass, the legislature can't touch. They can't alter it. They can't change funding on it. So they can do nothing with it. So the only way that we can actually amend or alter those laws if we have any unintended consequences is if we have more propositions in order to do it. And see, that's almost complete democracy. And democracies always fail because it's mob rule. In fact, Benjamin Franklin said that a democracy is basically 2 wolves and a sheep voting on what's for lunch. Right? Right? Mob rule. So we have majority rule in a republic. We have majority rule and protection by law. That's what makes a republic so brilliant. Democracies always fail the moment the people realize that they can vote themselves money out of the public treasury. They also fail when people realize that they can vote themselves money from people's property. Remember Mr. Smith and Mr. Jones? How 99% of the people voted to take that car from Mr. Smith? You see, they voted to take property from one and give it to the other. That's why democracies always fail. That's why the founders did not set up a democracy.
And also, the very next sentence there states that that our government shall protect each of them against invasion. Can you talk a little bit about that and our southern borders and how we truly are being invaded right now?
Absolutely. And the reason why that's not in the book is because when some of this seminar stuff was put together, this goes back quite a number of years, we didn't have quite the issue that we have today with some of our southern borders primarily, where we literally have millions of people coming across the border. And not only is the federal government not doing anything about it, but they are also suing the states that are trying to do something about it. But yes, that article, or that section, specifically states that the federal government has the responsibility to protect us from invasion. And it doesn't say what kind of invasion. It doesn't say military invasion, doesn't say political invasion. It simply says invasion. And so that's basically where they get the authority to protect our borders. And right now, as many of you may know, our southern borders are not being protected very well. In fact, in the state of Arizona, we put up some signs about 80 miles into the United States that basically warn our citizens. Well, we didn't put up these signs. The federal government put up these signs that warn our citizens that if you go beyond this point, there's a danger. And our governor at the time, she had a great response to that. She said, that's not a solution. That's surrender. Because we literally moved that border 80 miles by having this line that says don't go beyond this, because we have these cartels and others that are coming in here that are armed and armed well. I mean, they're military armed. And so yes, there definitely is an invasion happening, and it's a very, very concerning, especially to the southern states, especially when we decide to take it in our own hands and the federal government ends up suing us as a result of it. And their reasoning for suing that was basically they said, if we are not going to enforce federal law, then a state should not enforce that same federal law. And that was actually their argument in court. They didn't deny that the federal laws exist. They didn't deny that their responsibility is there, but basically they said, hey, if we're shirking our responsibility, you need to shirk that responsibility as well. Okay. So yeah, very important issue. So thank you for bringing that up. Then we have Article 5. Now you can start remembering these articles. Remember, the first three articles you can remember logically. Legislative, we start writing laws first. Executive, we execute those laws, and then we judge those laws to the judiciary. So Article 1, 2, and 3. Article 4 that we just went through very quickly is for the states. So you can just remember, Article 4 is for the states. Article 5, sometimes people remember it as the fix-it article. It's the amending article, so 5 is fix-it. Okay. So Article 5 is the amending article. The founders learned by mistake through the Articles of Confederation, in which they needed all the states to agree, all is your blank there. They learned that was an absolute mistake because that was minority rule, because only one state could hold all the other states hostage when they were trying to make some changes. So they put some provisions in Article 5 to amend the Constitution, and they gave us two ways. First of all, letter A, the first method was by having the amendment approved by 2/3, your blank there, of the House and the Senate. And then, number 2, approved by 3/4 of the state legislatures or state conventions. Now, this is kind of interesting. They can either send it to the legislatures and say, you guys need to approve this, or in that amendment they can say, this needs to be ratified by state conventions. So Congress can kind of bypass, they can't bypass the states, but they can kind of bypass the state legislatures by calling for conventions of the people. So the second method is to have 2/3 of the state legislatures petition Congress for a constitutional convention. Now, the first method is the only one that we have used so far. All 27 amendments have been passed using the first method. The second method has never been done, and it concerns quite a few people, but let's go through this method and then we'll explain it a little bit. Number 1, Congress calls upon the states to send delegates to a constitutional convention indicating the place and the time, the date. Now, what's interesting about this is the Constitution does not specify what that request from the states has to look like. So do you know that in the entire history of our country, there has been well over 700 requests from the states to have an amending convention. And Congress continues to kind of change the rules as they go. At first they said, well, all needs to be the same issue. And so then the states got together and they've asked for the same issue in the past. And then they said, well, the wording of what you pass out of your states requesting it has to be identical from one state to the next. So Congress keeps kind of pushing it off. But the Constitution doesn't give them any authority other than if the states ask for it, the Constitution says they shall call a convention, which legally that means they have to. It doesn't have any other criteria other than that. Okay? And the only reason why Congress has to call the convention is because it determines the time and the place. And the reason why it determines the time and the place is so that you don't have a handful of states that make it very inconvenient for a number of other states. You see? That's why you want Congress that represents all the people and all the states to basically have a say as to when and where this is going to happen. But they do not have a say as to what the subject is or how the calls came in. Constitution does not go into any detail on that. Okay? So once they call that convention, the convention of delegates from the various states can then prepare and vote on the proposed amendment. Now this indicates singular, but the Constitution doesn't say whether or not it's singular or plural. Actually, it kind of indicates a plurality. So it can be one amendment or multiple amendments. And then number 3, any proposed amendments must then be ratified or approved by 3/4 of the state legislatures. Now notice in this, the approval of Congress or the President is not required. Now in the first and second method, the President is out of it altogether. The President has nothing to do with the amending process. Okay? It's only the people and the states, because who is this contract with, this Constitution? People. Primarily with the people and the states. Mostly with the states, really. But it's with the people because the people were the ones that approved the contract between the states. You see? So the Constitution is a social contract primarily between the states, approved by the people, and so that's what connects the people to it as well. So as I mentioned, we've only used that first method. Now people are very afraid of the second method. They believe that if we put together what's called a constitutional convention, which I think is an incorrect term because the convention's intention wouldn't be to write a constitution. So the correct term would either be to call it an Article 5 convention or an amending convention. But a lot of people think that it'll turn into what's called a runaway convention, where it'll end up becoming this convention that ends up changing our entire system of government. Okay? And so they're very concerned about that. Now, last year, we had a conference at Harvard University, and it was all about whether or not we should have an Article 5 convention. And I was asked to speak to that, and I was actually there to speak against an Article 5 convention. Not because I'm against this provision. I think it's brilliant that the founders put in the Constitution a way for the people and the states to bypass Congress and still be able to amend our Constitution. But my contention was that we, the people, are not prepared because we do not understand these natural law principles that we went through in our history in these early lessons. And so I think that perhaps the only way we can solve our problems may be to have amending conventions. But I don't know that the people are prepared right now. That's why we're teaching all of you, so you can go out and get prepared and teach others, and then they teach others, and so hopefully we can be prepared one day. But to address the issue of a runaway convention, a lot of people have said that the original Constitution was an example of a runaway convention because they were only given the authority to amend the Articles of Confederation and not the authority to write the Constitution. Now the problem with that is to believe that means that we need to believe that this document is illegitimate or unauthorized. So first of all, I certainly disagree with that. But as we see when we get into the ratification in Article 7, the ratification process actually was much more stringent than what the Articles of Confederation originally called for. So yes, there are some concerns about an amending convention, but I don't think we should discount it. And one reason why I think people are fearful of it is because it's never been done before. But the one thing to remember is that the first method had never been done before prior to the First Amendment either. And it hasn't been the perfect method either. If you go through all 27 amendments, probably over half of them are not that good of amendments as far as the quality of legislative writings that they went into it, and sometimes their subject matter is not very good either. So anyway, Article 5 conventions, there is definitely a fear out there. Now, in the amending process, there are two restrictions. Shelby, do you have a question?
Concerning repealing amendments, is it the same mechanism as creating amendments?
It is. If you want to repeal an amendment, then it's amending the Constitution, because an amendment becomes the Constitution. Mm-hmm. When we talk about the Constitution, we kind of divide it up into a few sections. We have the original document, the Bill of Rights, and then the last amendments to follow. But really, all of it is the Constitution. And so therefore, if you want to repeal one, you still need to go through the same amending process. So, now there are these two restrictions. Number one, no amendment giving the federal government control over the slave trade was to be passed before 1808. 1808. So they put it right there. Not only did they put it in the body of the Constitution where it talks about what Congress can do, but they put it right here in the amending process so that that compromise would not be altered in any way. The other one is a very interesting restriction. Number two, it also provided that no state, without its consent, shall lose its representation in the Senate. This was a very important issue to the Founding Fathers. They spent well over half of the Constitutional Convention discussing the issue of representation. And one of the major issues that they were talking about is the states being represented. Do you know that once they finally voted on the method of electing senators, do you know what the vote was in the Constitutional Convention? It was unanimous. 100% of those present agreed that the state legislatures should be the ones appointing our senators to give the states representation in the federal government. And so they actually put the provision right here. No state shall lose its representation without its consent. Have states lost their representation without their consent? Yes. They have. The 17th Amendment, which we'll talk a little bit more in detail, changed the method of electing senators. Now the courts have said, well, but the states still have senators, so they're still represented. No. The state, when the Constitution talks about the states, it's talking about the state governments, the state legislatures. When it talks about the people, it's talking about the people, and the people of the various states. So yes, there were some states. There were a number of states that did not pass the 17th Amendment. They did not consent to losing their representation in the Senate. Therefore, I believe the 17th Amendment is a violation of this provision. In order to pass the 17th Amendment, it would have had to have a 100% ratification, because every state needed to agree to losing their representation. If we had a bill in Congress or even an amendment to the Constitution that said that the people of the United States are no longer going to be represented or be able to elect their representative in the House of Representatives, don't you think you would want to personally have a voice and a say over that? Absolutely. You wouldn't want just Congress passing that, or even your state. You would want the voice in that. Right? So same thing with the states. The states needed to have a voice if they were going to lose their voice in the federal government. It's a very important issue there. Article 6, federal supremacy. So Section 1, this is one of the things that the founders in the Constitutional Convention did to help encourage the states to want to ratify the Constitution. All debts is your blank there, contracted and engagements entered into before the adoption of the Constitution shall be as valid against the United States as under the Confederation. So they also did this in Article 4. They basically agreed to take on all the states' debts as well. So that was kind of that little carrot that they dangled. If you ratify this, then the federal government will take upon it all of its debts, all of your debts. And some of them had a lot of debt from the war. Now this was an amazing thing, because traditionally in the history of the world, if a country had a tremendous amount of debt, what it would do is it would reorganize its government, and then it would tell all of its debtors, well, we don't owe you anything. That was the old government. And the founders wanted to be honorable men and an honorable nation. And so they told the rest of the world, even though we're going to change our system of government, we are going to honor our debts. Isn't that an amazing thing? Yeah, it's fantastic. That really showed their integrity. Section 2, the supremacy of the federal government over that of the states. There are 3 areas which federal law, to which the laws and actions of the states are subordinate. Number 1, the Constitution. Number 2, constitutional laws. And number 3, constitutional treaties. But before we just go into believing that those things are automatically supreme, I want you to go ahead and open up your constitutions. We're going to read right here what it says. Article 6, so it's on page 15, at the very bottom paragraph. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made, under the authority of the United States, shall be the supreme law of the land. Okay, so I just listed those things. The Constitution, the laws of the United States, and treaties are the supreme law of the land. But there are some certain criteria. We read through that again. This Constitution and the laws of the United States, which shall be made in pursuance thereof, which means shall be made within the Constitution, or the way that the Constitution says, or the limits that the Constitution puts on it. The laws that are supreme are only those laws that are constitutional. Right? Then it goes on, and all treaties made, or which shall be made, under the authority of the United States. So all treaties made under the authority of the United States. Quite often, especially recently, the last number of years, last couple decades actually, the president will enter into these executive agreements with foreign nations. He calls it a treaty. We act as if it is a treaty that has full force and effect, but yet it's never been ratified by the Senate. So does that treaty have supremacy? No, because it must be done under the authority of the United States. And how do you know if a treaty has been done under the authority? It's got to be signed by the president and ratified by the Senate. Right? That's the authority. So if those two things don't exist, that treaty has no authority, therefore it is not the supreme law of the land. So we need to make sure, because a lot of times people just say, even with some recent legislation, it's the law of the land. Can't do anything about it now. It's the supreme law. We got to enact, these different things, these different aspects to the law. If it's unconstitutional, it is not the supreme law of the land. So very important point there. Section 3, to ensure complete loyalty to the Union, all senators, representatives, officials, and judges of the United States, as well as officials of individual states, were required to undertake or to take an oath to uphold the Constitution. Oath is your blank there. Now, what's interesting about the oath-making power, or the oath-making requirement, this shouldn't be a religious requirement, but what the founders said is we should do it in a way that binds the conscience the most. So, most of the time, how do we take an oath? Hand on the Bible, right? Raise our right hand, and what do? We say, basically, under God, right? And this is where you can end up taking the Lord's name in vain, because if we're using God as our witness, and then we break that oath, we've taken His name in vain, right? Now, what if somebody who is not a Christian? Do we still have them put their hand on the Bible and raise their... Does that bind their conscience? No. A few years ago, there was a representative that was elected who was a Muslim, and people were up in arms because he was going to give his oath on the Quran. Well, wouldn't that bind his conscience more than giving it on the Bible? So the founders would say, okay, that's fine. We want to bind his conscience. And so whatever binds the conscience the most is the way that we want to have them take the oath. So the founders never really had anything specific. They did have the specific oath, but never the manners to which it should be taken. Right hand raised or hand on the Bible or whatever. That was up to the individual. Then we come to Article 7, ratification. Not that big a deal here because this has already been done a long time ago. But a couple of important points is once the Constitution became ratified, which the Constitution said after 9 states ratify it, then it will become the law. Did all 13 states then become part of the Union? No. Only the 9 states. So 9 is your blank there. And letter B, there was no provision to compel states to come under the new Constitution. Compels your next blank. In fact, Rhode Island didn't enter the Union until almost 2 years after we had established the Constitution. And so Rhode Island began to be treated like a foreign nation because it was a foreign nation at that point. And then, in fact, George Washington was even angry about some stuff that Rhode Island was doing in relation to commerce. And so he actually sent some ships up there and created a blockade. And then finally Rhode Island realized they wanted to be part of the Union. And so they ratified it. But no, it was only the 9 states. So this is the point, going back now to this runaway convention idea. What the founders did when they were done writing the Constitution is they gave a more stringent requirement. So in the Articles of Confederation, originally it said that if you want to amend the Articles, then each state has to approve it. Okay? So what the founders said is once this Constitution's finished, we're going to send it to Congress. If Congress accepts it, they'll send it out to the various states, and then upon the recommendation of each state, they will call a convention of the people. So look at all that they just did there. Went to Congress, and guess what the vote was out of Congress? Unanimous. Okay? Then it went to the states, and all the states, state legislatures recommended, so now the state legislature was involved, recommended that the people have a convention. The people called their representatives, they had a convention. So now every single level was involved in ratifying. Okay, Congress, so the federal level was involved. The state legislatures was involved. The people were involved. So you had all those levels that were involved in ratifying that Constitution. So they made it more difficult. Secondly, this issue of whether or not they had the authority to even write the Constitution in the first place. There were some delegates at that convention that had the explicit instruction to only amend the Articles. But there are other states that were told, go there to amend the Articles or to devise a system of government that will best meet our needs. And so it was totally left for them to go either direction. When it came down to it, the final people that signed the Constitution, only 4 of them that signed it were actually some of those that were from the states that had specific instruction to not do anything other than amending the Articles. So technically only 4 of them that signed it did not have the authority to sign it. So there were still by far, the majority of the people at the convention had the authority to write the document. And the document also, the reason why the founders felt like they had the authority is because they really were not giving any binding authority. All it was just a convention to come up with an idea and to send it to Congress, who then has binding authority. So they knew regardless of what they voted for, wasn't going to take effect. It didn't have any binding effect on anybody. And so that's why it was not a runaway convention. So that kind of gives you some clarification there. Kelly?
Okay, so it's true that the people are not aware enough about these principles and natural rights and laws and things that we've been talking about. And so it could be a frightening thought to think about an amending convention or something like that. But if they are, I mean, they're already voting in repeatedly people who violate the Constitution all the time. I mean, so their ignorance is already showing and damaging things. So should we not just go ahead and try the other option?
Yeah, that's a great point. In fact, sometimes when people come up to me and they'll say, well, you know, if we had a convention, we don't know whether they'd be educated enough. We don't know if they would adhere to the Constitution. We don't know whether or not they would pass good amendments or not. And I'd say, well, wait, didn't you just explain Congress? Didn't you just describe? So right now we put the total amending power into Congress, which has actually proven to be runaway. And we're so afraid to put it in the hands of the people that have not proven to be runaway. And that's your point, right? Yeah, so I think that's a great argument that sure we should try the other way because the first way has failed a number of times as well. And the Congress definitely has run away when it comes to the Constitution. So yeah, I thoroughly agree with that point. Okay, so once the Constitution was ratified, it took effect. George Washington was elected, as you know, and Congress took their seats. And one of the very first things that Congress needed to do, because many of the states wouldn't ratify it without a Bill of Rights. And so George Washington and James Madison and others said, if you ratify it, the very first thing that we will do is we will write a Bill of Rights. And so that's exactly what they did. They followed through with what they agreed to. And so our next lesson will cover the famous American Bill of Rights. Thank you for joining us.